Hey guys, my name is Shashwat and I'm a legal intern at LEXIS and Company. In this video, I'm going to talk about the transfer of property. The transfer time for sale of goods involves the transfer of ownership of the property from the seller to buyer. For the following reasons, it is necessary to determine the exact time at which the ownership of the goods passes from the seller to the buyer. Firstly, the risk passes through the property. The rule is prima facie risk passes with the property. Then any action taken in the connection with the third parties, if third party damages the good, it is the owner who can take the action. Then what are the implications of the residency in case of either the buyer or insolvency of the seller? Then price suit. The seller's price suit will not lie unless the property has passed on to the buyer unless the contract provides for other reasons. Then there are some risks that you get to know when you separate the property. First of all, the goods are at risk of failure of the party where the delivery is delayed to the seller or buyer's fault. Second, a commercial custom can divide risks and good. Thirdly, the agreement between the parties can distinguish between risk and property. Then when property in the goods passed under the Sales of Goods Act, the sections 18 to 25 determine the ownership of the property passes from seller to buyer. This includes transfer of property in unspecified goods, transfer of ownership in ascertained goods, transfer of property in ascertained goods, then transfer of property in the sale by approval, then transfer of property when right of disposal is reserved. These come under section 18 to 25. After this, there is the transfer of title. Latin maxim says the nemo dat quo non habet. That is basic principle of the transfer of the title, which is mentioned in section 27 to 30 of the Sales of Goods Act 1930, states laws on the transfer of title. The Latin maxim says that no one can give what they don't have. So this is a very meaningful line and very true. Then there comes estoppel, which is if the conduct prevents the goods owner from denying the authority of the seller to sell, the buyer receives a good title. However, in order to obtain a good estoppel title, it must be proven that the original owner actively suffered or condemned the seller in question as a person authorized to sell the goods. Then there comes the sale by unpaid seller. If a non-paid seller uses his lien or stop in transit rights and sells goods to another purchaser, then the second purchaser receives a good title against original purchaser. In such case, therefore, title will be transferred. And lastly, there is sale under the provisions of other act. Sale by a company's official receiver or liquidator will give the buyer a valid title. Then under the circumstances, the sale of goods by a pawnee may convey a good title to the buyer. That is from my side.